technological organization. Now, because you are listed as guest, because it is a technical sort of, not because you are not the speaker, it's just basically we have to operate with Meta because we have a Gov email address. So you will be listed as a guest because you don't have a Gov. Thanks.
All right. Okay. Thank you. Thank you.
Okay, thank you, Helena. Thank you, Archibald. Welcome everybody joining this webinar. I'm Dieter Korczak, as Helena already introduced me. I'm a sociologist and economist, and I'm the actual elected president of the European Consumer Debt Network. We are an international association founded in 2007, and our focus is on fighting against over-indebtedness in Europe and to give a better provision of debt advice services all over Europe. The PEPPI project is a grant we received last summer, and the intention of the PEPPI project is to improve debt advice services in European member states where not a good service is in existence, like in Malta. As far as we know, Malta has nothing in this, no service, no specific service. Many other European countries, especially 12 other European countries, are in a similar situation, and our project intends to improve that and especially to give additionally information on financial education and on living with debt by a website. Now, by a national website. We have a kind of international website at our ECDN EU with a lot of information. We have a knowledge platform there where you can see most of the relevant studies and research done in this field. And we have an online academy where all our webinars we have done ourselves are available as PowerPoint presentations and available as YouTube videos. So this is a kind of online learning and training for everybody who wants to become a debt advisor. The project is now in the final months. We have to deliver our final report and our evaluation in December this year. We will have tomorrow a webinar where I invite you to join about psychosocial consequences of debt, with very interesting presentations from Ireland, Sweden, and Germany. And yeah, I think that's it more or less. And our vice president, Dr. Pauline Dujardin from ECDN, she is a lawyer and a legal expert, and she will later on give information about the specific legal situation in France. We are, and I have posted it on LinkedIn because we are quite active, not only with our website, but on LinkedIn and Facebook as well, with, the most actual news. It's a kind of blog we have there. And I just posted how happy we are and how highly we appreciate that the new Consumer Credit Directive has been now adopted the last days, which means that each EU member state has an obligation to provide debt advice services. So as Helena said, our project started before, but now it's fantastic that just in the middle of our project, this European directive has been adopted. And so Malta has the obligation to do something, at least to start with some pilots or, and that's a very good situation for everybody of us who's engaged in the fight against over-indebtedness. Yeah, and wants to support and help people. So thank you for being here today. Thank you for your attention, and wish us a very informative and vivid presentation. And I know Pauline, she's French. She's always very expressive. So have a nice webinar.
Thank you. So we can go ahead, Dr. Kalea, so you can introduce us to the legal concepts tied to debt and creditors and, maybe, yes?
You were about to say something?
Yes, I don't know whether you want to remark also on anything that Professor Korczak spoke about as well.
Okay, so first of all, thank you all for having me here today, and to have me participate in this very interesting project. It is something of a pet peeve of mine, this thing of insolvency here in Malta. Professor Korczak, thank you very much for your very interesting introduction, and I would very much, and I trust I shall have the time to attend this webinar that you have mentioned regarding the psychosocial effects of debt, which is going to be held tomorrow. Of course, in order to do that, I'm going to need to have a link of some sort, because otherwise I won't be able to attend. I don't know how many of my lawyer colleagues, I know that we have Mr. Jourdain over here from France, but I don't know how many other lawyer colleagues of mine are attending this webinar. So given that I am not, to use a French expression, au courant with most of you, if not all of you, I don't know if any of our guests here are, as a matter of fact, legal practitioners. If they are, if any of you are, I am sorry if I am going to bore you to tears with a repetition of debt 101 as we will go over it in university, in our university studies. However, I do hope that I will be able to pepper this introduction with my experience and with what we are actually witnessing, so to speak, in the legal market. It is interesting as well that we have Dr. Jourdain or Mr. Jourdain over here from France, because France, Malta, Italy, Germany, Spain belong to the same legal family, and that is, we are civil law traditions, we are civilists, and we have, especially as an island, we have borrowed quite a lot from the Italian civil code and the Italian code of organization and civil procedure. We owe this to Sir Adriano Dingley. These were drafted way back in the late 1800s. And there have, of course, been a number of amendments carried out to these two codes, the Civil Code and the Code of Organization, and then later the introduction of the Companies Act. Now that is the introduction of the Companies Act, and I'm mentioning this as an aside. I understand that this webinar regards personal indebtedness, personal insolvency, but there is something to be said regarding the Companies Act and the insolvency provided for, the insolvency provisions provided for under the Companies Act, which I will leave, so to speak, on the bench for the time being. So on to personal insolvency, and the first thing that I need to say over here is, ladies and gentlemen, that no surprise to anyone, unfortunately, Malta does not have a personal insolvency law. It does not exist. That does not mean to say that Maltese legislation acts as if insolvency doesn't exist, or it is blithe as to what insolvency is. However, an examination, even a cursory examination of the Civil Code, which I have mentioned before, Chapter 16 of the Laws of Malta, and Chapter 12 of the Laws of Malta, the Code of Organization and Civil Procedure, and therefore the laws which enforce the obligations found in the Civil Code, give you the tools with which to enforce those provisions in the Civil Code. You will find that a cursory examination of these two codes will mention insolvency as an incidental matter. So, for example, just to give a brief example, the civil code will say what happens if a co-heir to an estate becomes insolvent. What happens if the co-heir becomes insolvent? What do you do then? What happens if in a general partnership one of the partners declares or is declared insolvent? What happens then? You know, and so it's as if, well, it's not as if, it is in fact this way, that the legislator at the time did not have the problems of insolvency that we are seeing today, did not have the problems of bankruptcy that we are witnessing today. And there could be a number of reasons why we are witnessing so much bankruptcy today, so much insolvency today. And we could enter into a separate discussion which has nothing to do with the law, and which, of course, I am not competent to discuss, because I'm not a sociologist, I'm not an economist, etc., etc. So as I was saying, therefore, Maltese law deals with, if we want to say deals with insolvency as an incidental matter, and deals rather with specific consequences, therefore, of insolvency. And therefore, when it comes now to the Code of Organization and Civil Procedure, and a creditor needs to see what he can or she can or it can do to recover a debt which is due to it, it is a variety, yes, of mechanisms which are available to it, and which I will briefly introduce over here and now. However, there then is no corresponding, there are no corresponding provisions of the law in the same code or in any other code for that matter, where the debtor now can file for bankruptcy protection. It doesn't exist on an individual level. It does not exist. So let's look at the creditor landscape. Okay, so let us say that from the outset, looking at Maltese law, you could almost say, hey, you know what? Maltese law favors the creditor, and that is because there are a number of mechanisms which the creditor can use to attempt to recover his debt. But it's not really true, because as we shall see, they are not very, in truth, in reality, not very effective mechanisms. So let's start from here. So there is an outstanding credit. The creditor would like to enforce his claim against the debtor. What can he do? Let's start with private law. So privately, it is possible for the parties, the creditor and the debtor, to enter into a contract, which is called a constitution of debt, which is a public deed signed before a notary public, where the debtor declares himself to be owing the creditor this amount of money, certain liquidated and due, very important, certain liquidated and due, and that he is now, the debtor, is now guaranteeing the payment of this amount of money within a certain period of time. And in order to warranty that payment, the debtor enters onto the constitution of deed, and I trust my French colleague will understand me over here, a number of hypothecs and privileges in order to guarantee the payment of this debt. And the hypothec in English law, it would be known as a lien or a lien, depending where you're from, I suppose, in the United Kingdom. These are privileges which typically, though not necessarily, attach to immovable property which may be in the possession or ownership of the debtor, and whereby he is guaranteeing the payment of that debt and securing it by constituting a privilege in favor of the creditor over that immovable property. So that's the first thing. It's the simplest, let's put it this way, easiest method whereby a creditor may seek to secure his claim. From there, it becomes contentious. So immediately, if you're not going to have the cooperation of the debtor to enter into this public deed, you immediately then go into the contentious, and then we start therefore with official letters placing the debtor in default and warning him that if he does not pay this debt within a certain amount of time, judicial action will be taken against it. What judicial action can be taken? The judicial action that can be taken is this. First of all, the creditor will try to secure his claim prior to the commencement of judicial proceedings, and he will do this by issuing against the debtor any amount of warrants. So there are a number of warrants which are provided for in the Code of Organization and Civil Procedure, starting from Article 836 onwards of the Code of Organization. There is the warrant of seizure, there's the garnishee order, and there is the very famous and really unused warrant in facto. I will explain what that is later. So the garnishee order is a method by which the creditor who has I will try to explain for my non-legal colleagues in this webinar, a prima facie expectation of a credit. Prima facie means that on the face of the record, the creditor is right in wanting to secure this claim. And therefore, he has a claim of X amount of euro, and he files this warrant against the debtor, which is then served on a number of local credit institutions. Those credit institutions are typically banks, but they are also the government of Malta, the VAT department, the controller of customs, the commissioner of revenue, the registrar of courts, etc., etc. And you have this whole laundry list of potential sequestrators, we call them, who may be in possession of the funds or some of the funds that the debtor may have, and who will, as a consequence of this warrant, be ordered to deposit those funds under the authority of the court up to the amount that the creditor is seeking to secure. Once this warrant is filed, whether or not the credit institutions, as aforesaid, actually do find in the possession funds belonging to the debtor, whether or not they have these funds, they have to respond to the warrant within 19 days. And whether or not they have these funds, the creditor will have to institute his action against the debtor within 20 days. If he fails to do this, and I have, as a matter of fact, a case which is like this right now, going on right now. If he fails to do this, they file the case, the creditor filed the case within 21 days, the debtor will be entitled to file a counter warrant and get that warrant vacated, dropped. So that's the first step, so to speak, in trying to secure the creditor's claim. Of course, the debtor on his part, typically, let's put it this way, seasoned debtors, all right, I think everybody knows what I'm saying over here, people who abscond from their obligations for one reason or another, would know what to do, in the sense that they would already, in advance, owing a lot of institutions, a lot of people, a lot of money, they would already know not to keep any money in these institutions on the names. They would already know not to keep any immovable property, not to hold any immovable property on the name. So over here, when the creditor tries to secure his claim or file his claim, he will find himself bereft of any assets which he can seize belonging to the debtor in order to satisfy his claim. As I said, the next step after this would be judicial proceedings. But there is another warrant, and I have already indicated what that other warrant is, and this would be the seizure of immovable property. So there is a possibility, apart from seizing funds and liquid cash from these credit institutions, the creditor can file a warrant for the seizure of immovable property, where he would seize and prevent the debtor from selling, transferring, or alienating any immovable property which is in his name. And the whole scope of this is that then the creditor would institute an action before the court, obtain a judgment in his favor, liquidating the amount which he is claiming in the claim, and then moving to sell the movable property belonging to the debtor by judicial sale by auction, and recovering from the proceeds of that sale the sum which is due to him. Naturally, if the property is sold for less than the value of the claim, the creditor would recover all that money, except in the case of a concursum creditoris, and I will explain what that is later. Okay, so that's the second warrant. The last warrant, and please don't laugh, this is true, it does exist, the warrant in factum. I don't know anyone who uses this warrant because it's too expensive for the creditor to use, and I will explain. So in Malta, there was a time way back, going back to the British period, when Malta was still a British colony, where we had a debtor's prison, okay? We had a debtor's prison. In other words, and this existed in the United Kingdom as well. I don't know about the rest of Europe. Presumably, it existed in the rest of Europe as well, where if you were a debtor and you were declared to be in default of the credit due to your creditors, you would be sent to a special prison where you would be kept until such time as your credit was satisfied. Now that has since been abolished. However, surprisingly, rather recently, the warrant in factum came into existence about 10 years ago, 12 years ago. We saw an amendment to the Code of Organization and Civil Procedure, whereby this warrant in factum would allow the creditor to place the debtor in handcuffs at and become a guest of the director of the Corradino Correctional Facility, which is our state penitentiary, until such time as the warrant is maintained. What does this mean? Because in order for the creditor to have this warrant in factum executed, he will have to pay for the debtor's stay in prison, which is something to the order, if I recall correctly, of something like €5 per day. Now, the thing is this. If you have a credit to collect, you don't want to throw, the English expression is good money after bad. You don't want to invest more money because you already want to collect €50,000, and you as a creditor you're going to say, I'm not going to keep on paying for this chap to be placed in prison, and it's going to be a greater financial burden. Apart from the fact that there's the obvious. If the person is locked up in prison, there isn't very much scope for him to work. He's going to be fed, he's going to be clothed, he's going to be housed, institutionalized, and there isn't much scope for him to pay off his debt, and he doesn't have much possibility to pay off his debt either, because if he was gainfully employed, he's now lost his job. If he wasn't gainfully employed, he certainly isn't going to get a job from within the prison. So quite frankly, even though this is on the statute books, I am not aware of it being used. Having said that, it doesn't mean anything. It could be that this warrant in factum is actually being used, and I just simply don't know about it, which is would be a bit remarkable. But anyway, I started off this introduction by saying that the number of measures that are available are not very effectual. And I say this because I say this at the behest of what is happening in our legal landscape, that you've got debtors who are notorious debtors, who are wise debtors who inform other debtors. It's like a club, and they inform each other what they have to do, and Malta's a small island, so news travels fast, etc. I'll give you one example. Which I haven't mentioned yet. Shame on me. I shouldn't have skipped this, because another legal measure which a creditor can try to use to recover his debt is a special official letter. So there is this official letter. And I mentioned these at the beginning: official letters to place the debtor in default, etc., etc. Official letters also serve the purpose of interrupting prescription. Very important in the case of civil debt, because civil debt extinguishes itself unless it's backed by private writing or a public deed by a period of 2 years. So if you fail to take any judicial action for 2 years, the creditor loses his right. If there is a private writing, an agreement written by the parties, then the prescriptive period would be 5 years. If there is a public deed, like the one I mentioned, the constitution of debt, then the expiration period, the prescription period, the statute of limitations would be 30 years. But then there is this particular official letter. It's the official letter which we call the official letter under Article 166A of the Civil Code, whereby you can avoid a lot of legal headache and expenses by sending the debtor this official letter. He will, at the top of the letter, there is this warning. There has to be this warning, otherwise the legal letter is invalid, where if he does not, or she does not, or it does not respond to this letter within 30 days from being officially notified, then the letter will constitute executive title. And by that, what is meant by executive title is that it would be tantamount to the creditor having obtained a judgment against the debtor, the judgment having become final and therefore enforceable against the debtor. Now, even this, so this was introduced about 15 years ago now. What has happened, obviously, is, and I say this to my clients in my practice who are creditors, I have to inform them, of course, because I have to give them, full information and full and complete advice. And I tell them, listen, there is this possibility. Instead of opening a court case, you can file this official letter, 166A, and what have you. But I also advise them, listen, who is your debtor? Is your debtor a notorious debtor? Is your debtor Maltese? Because if the debtor is Maltese, he or she would typically know that all they have to do if they receive this letter is file a note in the acts of this letter and simply say, I owe you nothing. And that's it. The effects of this letter cease. And you might tell me, yes, but it's always worth a shot. It's always worth a shot. Yeah, it's always worth a shot, perhaps, except for the fact that this letter 166A is typically a bit more expensive than your normal average official letter. And again, it's always a question of the creditor not wanting to invest more money than is absolutely necessary in order to try and recover or secure his debt. So, whereas, therefore, you've got these means at your disposal, the creditor has these means at his disposal to try and secure this debt. There is no means for the debtor to seek bankruptcy protection, and there is no means whereby the individual creditor can seek to stop the debtor from obtaining further credit. Because the thing is this, with personal insolvency laws as they exist in the United Kingdom, in Italy, I don't know about France, Spain, and Germany, but I can vouch for the English, United States, and Italian laws. When you consider the insolvency laws in those states, those laws do seek to provide bankruptcy protection for the insolvent, mostly from the insolvent himself. And therefore, the consequences of bankruptcy protection would be to place the debtor in a situation of incapacity, where he would not be able to enter into public contracts, would not be able to obtain loans. There would be a register which is being kept so that the banks would be able to consult this register and decide upon the risk, and therefore not extend a loan to that particular individual who has sought bankruptcy protection. And therefore, protecting the insolvent, the bankrupt, from himself ends up protecting the larger market, the larger creditor market, from further abuse. And therefore, as well, and we have not even discussed, by the way, and I mentioned this by the by, the consequences of indebtedness here in Malta. I don't know about our fellow member states, France, Germany, Italy, etc. I don't know whether they have a problem in those states with usury, but it does create a problem of usury over here. Usury, Professor, because I'm seeing you shaking your head, usury is the English term. The Maltese term is usura, and it is the same term in the Italian language for money lending on the black market, where interest rates are typically, obviously not the legal interest rates, would exceed 8% per annum by far, and whereby individuals become slaves of these money lenders who then enforce the claim in very different manners than I am advocating for over here, if you understand what I'm saying. So these money lenders would have, you know, these heavies who would go over, break bones and twist arms, etc., and they would secure the claims these ways. And this obviously creates a social problem as well, because you have then sectors of Maltese society who are beholden to these money lenders, which continue to precipitate problems in a spiral fashion, whereby these people are continually spiraling downwards. Miss Helena, Miss Holland, Mr. Rutard, I don't know whether you would like me to elaborate any further on Maltese law. I think I have taken up quite a bit of time over here, and I'm sorry if I have. But the subject
actually it was very, very interesting and illuminating, because sometimes we struggle to get more information about that and the legal perspective, at least from our part, from you know, when we try and ask for individuals rather than in Malta you can find lots of information when it comes to companies and that, but not about individuals for personal, you know, debt. So it was very interesting for us. I think now we can ask Pauline to give us the French perspective, which will be interesting for you too. And Archie, will you be
yes,
doing the presentation? Then she can tell you when to switch the
Thank
pages.
you.
Or all right,
yes,
thanks.
please.
Hi everyone, I'm sorry I don't make the camera because my connection is not so good. So I prefer you to hear me than to see me. So today I will present you the French over-indebtedness procedure, a little history, and then I will explain to you how we, Cresus, a French NGO, we used this legal frame to exist and to make our activities, and then we will finish with a little bit information about the credit directive, which Dieter spoke about in the introduction. So first, a little bit history, please. Next, thank you. Just to explain the context in France, the consumer credit market in France was developed in the 70s. And especially the French wanted to support the home ownership with public aid, and for example for credit with to make the house better. And first thing was for the French legislation to make a protection about credit distribution and not over-indebtedness. So late 70s, we had this Scrivener's law, which make some mandatory informations, right of withdrawal. So the idea was really to protect the consumer by the distribution of the credit. In the 80s, we had some deflation period. The problem was inflation rate to which wages were attached was lower than the borrowing rates. Second thing, we have the credit crunch, sorry, has opened to market to new types of distributors, not just banks, but also credit organisms. And it's really late 80s that we saw the first emergence of the households over-indebtedness as a social phenomenon. We had at this time around 200,000 over-indebted households. Please, next. Then, and that's why in 1989 we had this NAIAPS law. So it's the introduction of an insolvency procedure for private individuals. This legal frame was really about implementation of debt rescheduling plans and it was a sort of grace period. So the procedure at this time was not so protective, but it was a first step. That's almost at this moment that created Crisis, my organization, which is an NGO. And the idea was really to help people who were over-indebted to understand the procedure in France and to help them in each stage. I wanted to show you how the procedure in France, and then I will show you the procedure now, evolved in the direction of more protection for a particular person and over-indebted household. So in 1998, it was introduced that we could have, so over-indebted people could have a partial erasure of debts. In 2003, before 2003, the rescheduling plan were not limited, and in 2003, the maximum duration of this plan was 10 years. And most important, we created this personal recovery procedure de rétablissement personnel, which provides that person in an irretrievably compromised situation can see all their debt erased. And that was really a big step. This possibility was created, I would say, parallel to another procedure which exists just in some of region of France, Alsace, it's east of France, which had a procedure which permits to apply the insolvency procedure of enterprise to personal people. It was just in a region, but in 2003, the French government decided to make this possibility for every people in France. In 2010, we transposed the credit directive in French law, but I think I can say we over-transposed it. So we have the chance in France to have much more protection than the normal protection of the directive. The plan for debt were limited to 8 years, and then in 2014, the plan will be reduced in 7 years. Next, please. Archibald? Thank you. That is the French over-indebtedness procedure. I think it's important to say that it's an administrative procedure. So if no creditors or debtors contest a decision, it's just by mail, just by letter. So first, the over-indebted is characterized by the manifest impossibility of meeting all of one's non-professional debts due and falling due. The idea is really that this procedure is reserved to a personal person and not enterprise. So you can submit your file. Then in 3 months, the Banque de France, that's the institution which deals the over-indebtedness procedure, will admit or not your file. When you have this admissibility, and I think it's really important, there is a suspension of debts and monthly credit payments. We always say to our clients that they can breathe again. What is important too, during all this procedure, no creditors can make some civil enforcement proceedings. So if and more, if there is already enforcement proceedings, for example, seize the salary, it stops. Then the French Banque de France will decide if she considers that debtor have repayment capacity or no repayment capacity. If the person has repayment capacity, the Banque de France will introduce a repayment plan from 7 years max. And for all the debts which is more than this 7 years, they are erased. When the Banque de France considers that the people has no repayment capacity, it can be in the first stage a cancellation of all debt. But if the person has already, thank you. But if the person has patrimony, for example, his home residence, a principal residence, this cancellation of debt is added to a liquidation of assets. So that's a French procedure. What I said is, here in Crisis, my NGO, we worked with people who were already over-indebted. But we wanted in 2008 to act in prevention. Why? Because when people are already over-indebted, we just have the solution, which is great, of over-indebtedness procedure. But if people are coming sooner, and I think that's international, we can have so much more possibility to help them. So we decided to create another structure with the purpose to prevent over-indebtedness by focusing on social innovation opportunities. And the idea was we asked ourselves, who can tell us when the people is not already over-indebted, but will be over-indebted. And these persons are banks and financial institutions which are seeing the financial situation of the people. So we decided to open the discussion with banks and financial institutions to work with them on the financial distress of their clients and their support outside any legal firm. So there was nothing at this time. But the other idea was really to be independent from the government and political decision and subvention. And we wanted to establish a trust relationship with creditors to make them improving the treatment of the clients who are in the financial difficulty. So I don't know for Malta, but here in France, it was really an innovation to accept as an NGO to work not for banks and financial institutions, but with them to prevent over-indebtedness. Archibald, you can go next. Thank you. So the first step was to respond for a call for tender presented by La Banque Postale, that's a big bank in France, which contains support to the vulnerable customers. So we applied to help La Banque Postale with their financial institution. But we didn't succeed, and we decided in 2009 to work with a big French credit institution. It's CTLM, which is a part of BNP Paribas. And this French credit institution lost this call for tender and took the idea to work with Crisis. And in 2010, there was an evolution of the legal frame. I really think that it's because what we did with all of the credit institution of the banking inclusion charter in France. Next, please. So in the 2013 law about the separation and regulation of banking activities, there was many obligations for banks and credit institutions. For example, to offer adapted services to the needs of vulnerable customers and something cheap. And this law said you have to sign the Charter for Banking Inclusion and Prevention of Over-Indebtedness. Parallel, it was created a Banking Inclusion Observatory, which collect information on access to banking services, define products and analyze indicators of banking inclusion and financial vulnerability. Next, please. And that's a part of this banking charter, which said that credit institutions, payments institutions, and so undertake to offer their customers whom they have detected as being in a situation of financial fragility, appropriate internal responses, and in particular two. offer a meeting with the customer concerned in order to discuss his or her difficulties, but that was intern of the credit institution, and if necessary, provide the customer with information on a third party that can help him or her, or even with the consumer agreement, put him or her in touch with that third party. And that's where CRESIS, our foundation, which act. Please, next. You can go next. So this charter was created to make to encourage some partnership between banks and NGO to help the financial client. The idea is that a credit institution, as you saw, have a risk in the over-indebtedness procedure. What is this risk? They can have some debt erasure, and they don't want that. So it was really an argument to promote our action and to promote collaboration with us. The idea of this charter was really it was a will to make the credit organism actor of the prevention of over-indebtedness. As I said, they have advantage to work on it, and they can just create their third structure to our clients. So we have new almost NGO, Parcours Confiance, Point Passerelle, which are created by the banks, or by working with a strictly independent structure which is specialized in debt advice. And the example is CRESIS for us. Next, please. So the purpose of our foundation is to prevent over-indebtedness by focusing on social innovation opportunities, and we wanted to work alongside financial actors to detect clients in financial distress, and if possible, before the situation of over-indebtedness. And then we, in CRESIS, we opened a national phone helpline, and as a trust party, this platform in Strasbourg helped the beneficiaries to make a diagnosis of their financial situation and provide them with appropriate recommendation to resolve their financial problem. So the solution for the beneficiary can be to go in over-indebtedness, because perhaps the bank doesn't know, but the household is already in over-indebtedness. But we offer a special service because we are working with many credit organisms, which is a service of mediation. And the idea is really to increase the beneficiaries' money available each month by renegotiating their monthly credit payments. And because the credit institution trusts us, because they know that if we ask a renegotiation that it can work, we don't make mediation just to make mediation. It's really to avoid over-indebtedness. Next, please. So that's a process, how we work. So detection by the partner, then the beneficiary agrees to be helped by CRESIS. I have to say, and it's normally I have to say it first, when we have information for the client of the banks, we don't give this information to the bank. So we really are a third party, and we really work in confidentiality, because we know that it is only possibility to have all the information of the beneficiary and to work with them to resolve the situation. Then when the beneficiary agrees, we can make some financial support, loan mediation, insurance mediation, and we developed a new area for SMEs. Next, please. Or you can go next. I already explained the mediation process. To build this foundation and to build this structure, we wanted to make all the debt advice activities of the foundation based on prescriptions. That means that the bank and the credit organism are paying 200 euro per file, and then a fixed sponsorship, which depends on the size of the institution, and that's to finance our area and of CRESIS. To be honest, that's a big point, I think, to motivate credit organism to work with us, is that there is a law in France which give benefits from a tax reduction when you make a sponsorship to an NGO. What is important is that our support stays always free for the beneficiaries. Next. That's a table, and perhaps I won't be too long, but that's a study from McKinsey which shows the cost avoided for state and for financial institution with our action increases. So you see the number is kind important. Next, please. So arguments in favor of a partnership with CRESUS for this banks and credit organism are to build a fidelity with the clients, because they know that when the bank help the people to avoid over-indebtedness, they build a fidelity with their clients. Other arguments are economy by avoiding over-indebtedness and so debt erasure, and improving the corporate social responsibility of banks and financial organisms. Next. The principle is to stay open, because for NGO it's not always easy to work with banks and credit organisms. Stay independent, because it's really important. At the beginning of our work with credit organisms, some of them said to us, "You counsel, your recommendation are too much to make over-indebted file." And we said, okay, that's not a problem. If you are not happy, you can stop working with us, but we are independent and we don't need you to be existing, because we are working with many credit organisms. Be pragmatic, because I think what is important for them is that we prove our action and how our action can be or impact and get recognized by the state. We are not a big institution, but we are listened by the government when they are working in debt policy or, for example, in the next time, the transposition of the directive. Next, please. Or you can go next, because I see there are not so much time. I wanted to speak about the Article 36 of the new Consumer Credit Directive. This article is really important because, and Dieter mentioned it, now every member state shall ensure that independent debt advisory services are made available for all people who are experiencing some financial difficulties. But I think the second line is really important too, because creditors must have processes and policies now to for detect the consumer experiences financial difficulties. So the idea is really to act in prevention. And I hope that this, the transcription of the directive Sorry, I think I had a problem. I hope that this legal frame will motivate all creditors to work with NGO to avoid over-indebtedness and to act in prevention. And last one, but I won't be long. I wanted to show you that even if we are working with credit organism, we speak in the press. It's not because we are working with them that we can't say that there is a problem with bad credit and with unresponsible credit. So thank you. Perhaps if there are some questions.
I don't know how we want to move here, Miss Holland, but I would have a question for my French colleague. Shall I go ahead and ask, or?
Yes.
Yeah.
Yes.
Okay. I would, Ms. Desjardins, I would have a lot of questions to ask you, but I'm, of course, going to limit myself as much as possible, especially following this first encounter of ours over here. I was very interested when during your very interesting presentation. Thank you very much for your interesting presentation, by the way. You listed these instances of erasure of debt, maximum payment plan of 7 years, maximum payment plan of 10 years. I would be interested to know, I don't know whether Cressus has done this or whether this information has been made available to Cressus or I don't know, by some government institution in France, as to the consequences of this debt erasure, if there have been any consequences of this debt erasure on the credit market. Because as you know, the credit market is a motor of the economy. Okay, so as a matter of fact, typically, you have spoken about Cressus as an NGO working with, as a third party, working with primarily bank institutions who then have to offer sponsorship, etc., etc. So primarily, the credit market, most important credit market, is a motor of the economy, and I am interested as a practitioner, and I must inform my Maltese guests over here, who is also now extremely interested in possibly setting up a foundation here in Malta regarding this, but that's an aside. Apart from this, I'm interested to know what impacts, if anything, this has had, because this has started in France in 1989, and then we saw the Scrivener's laws. What impact, if any, has this had on the credit market? The fact that, you know, a debtor can say, you know, oh, it's not much of a problem. I can have my debts erased, you know, and there could be the erasure of my debts. I would have a payment plan of a maximum of 7 years if I don't manage that and I don't have any assets. What impact has this had, if any, Ms. Desjardins?
To be honest, I think I'm not sure about the responses, but to be honest, I think this procedure was created because people won't pay anyway. And to be honest, in credit institutions, they are often already in loss. So I don't think I really think that French market is not so good in the credit distribution, but I think it has a real impact for them to work about it because they want to avoid erasure of debt. But our procedure is limited in the conditions, so there is a real so you can't have something like 3 erasure of debt in 10 years, you know. The idea is really then when you have this clear erasure of debt, you can't do some credit for 5 years. When you have the plan, you can't do some credit during the plan. Then if you submit too much file, over-indebtedness file, the Banque de France and the judge will say you are not in good faith. So you are excluded of this procedure.
Okay.
And the idea at this time is really to show that the household makes some efforts and then perhaps submit again the file. But I think it's there are some conditions, and what I see in France is that's I don't know if I can say that, but that's a punition of false distributing of credit, unresponsible distribution of credit. So credit institutions are not white in France, and I can't say that just responsible credit distribution, but that motivate them to work on that. And I really hope that with the new credit directive, much more, so we have now the problem that, for example, the buy now, pay later are not credit, or the mini credit. So the new directive will help us to motivate other institutions who has nothing of regulation.
Thank you.
Okay, Dieter, if you want to make an intervention as well, since you commented before.
Yes, I mean, I can support the idea that there is no negative effect on the credit market at all. We have even in Germany even a stricter personal insolvency law, because we started with a grace period of 7 years in the year 2000, and now following the change of the company insolvency law of the European Union, it's reduced to 3 years. So grace period of persons who have been accepted by the court, and there is a debt regulation scheme, can get rid of debt within 3 years. It's the United States idea of giving a fresh start to people, to bring people back into the system, into the credit system and banking system. And we have this big registration company, Schufa in Germany, where all the credits are registered, and they have a default rate of 2% of all the, let's say, 50 million credits, 50 million loans per year. And it's just a default rate of 2%. And despite what they are doing, the default rate remains the same since insolvency law, before insolvency law, and so on. And we say from the analytical side, the default rate depends on the marketing activities of the banks. If they give credit and loans to people who shouldn't get a loan because they are financially weak, and they do it instead, then you get at the end a default. But the insolvency, we have like over the years around 100,000 personal insolvency cases in Germany, and the effect is positive. There is no carousel, as you can think. Somebody gets out of debt and then he starts again, and the percentage of really people who are cheating the system is below 5% of all the ones who are in this insolvency procedure. This is something you will never avoid. You will always have a very small, number of people who are just, don't behave in the right way. They are take free rider positions or something like that. But we just can say insolvency law. I was, as you mentioned, that you can get into prison by debt, the debt tower, which is still in some German cities. You can see that debt tower. This is thanks God, or thanks society long ago. The last country in Europe who had this kind of getting into prison was Ireland, but it stopped there as well years ago. So we just can say from my German perspective, and from the general European perspective as well, an insolvency law with all the restrictions within the law Pauline mentioned. I mean, because you have to behave in the right way. There will be a trustee who looks for your money you get. You are not allowed to take new credits as long as you are in that grace period. There are so many barriers and steps to avoid that somebody cheats the system, and I think it's good for society and for prevention and rehabilitation of people who are in debt. That's That's an important thing as well, the rehabilitation, Somebody, we know that most of the people became over-indebted by reasons which are not their fault, like unemployment, sudden unemployment. They were working for 20 years for a company. They thought this is forever. Then the company was taken over by another one, restructuring, unemploying many people. So, and they had loans, so they couldn't pay. Or divorce. Divorce is something you usually don't plan. When you marry, you believe it's forever. Romantic idea of being a couple. For many people, this doesn't work at the end. And then you have diseases. If you get cancer or you get a psychic problem, which will be tomorrow, we will talk about these cases, then you are not able to work anymore. And it's a big question whether over-indebtedness makes ill or whether illness makes you over-indebted. So this is like the hen and the egg. You cannot really solve it. It's both happening. Thank you.
Thank you.
Okay,
Professor.
Pauline.
I just wanted to add one thing about French system is when the over-indebtedness procedure was created, it was really oriented to credit organism and credit. But what we see today, and because the law in France, and I spoke about it, the credit directive in 2010 was over-transposed. What we see today, and with the inflation problem, is that more and more people are submitting file of over-indebtedness, but just with fixed charge and no credit, and that's really a change we see today. I know it's perhaps weird to say that to you in Malta, because I think your standard of living are not the same as us, but our problem is now that wages are not enough to pay the charges, and that's really our problem. But with this inflation problem, we see also that people, so we don't know, but we think, and we are scared of it, but we see it was on the first quarter of 2022-3, the distribution of consumer credit increase was more important, and we are scared that people are taking credit to pay their charges. So we will see, I think, in 1 year the consequences of that.
Excuse me, Mr. Jourdain, you lost me there for a while. It could be the communication isn't too clear. You said charges. What charges are you referring to? Because
rent, for example, or energy, or those costs.
Okay. So this is therefore the reference to our standard of living. All right. Okay.
Exactly.
So you're saying that there is a fear in France that people become indebted in order to pay their utility bills, in order to pay the rent, etc., etc. Well, I don't know what my colleagues have to say about this, but this is certainly a phenomenon which is in existence in Italy. So you have Italians who are taking out loans in order to pay their exorbitant utility bills. I don't know whether this has anything to do with inflation or whether it's something else, or whether it's the Ukrainian crisis, or I have no idea, the war in Ukraine. I have no idea. And sincerely, we have a representative of a foundation here in Malta, Tita Malta. I don't know what they're experiencing. I don't know whether they are experiencing citizens who are taking out loans here in Malta in order to pay the charges. As a private law practitioner, I have not seen this yet. Though, incidentally, this is something which I forgot to mention. Because of what is happening with credit here in Malta, because of the deficiency in legislation, the market has reacted on its own, so to speak. So over the past years, we saw the setting up of private institutions, like, for example, Credit Info, MACP, which are institutions which study the credit market and which advise on notorious debtors. To this extent, and we are subscribers to these, and we obtain information, so they act as registers, so to speak, of this debt. And one of the things that we are witnessing, for example, is that utility service providers, so I don't know, cable television, mobile, internet, water and electricity, and telephone companies are instituting judicial procedures in order to recover monies due for debts payable on these bills. Now, I'm going to be honest with you, I have no idea, though I deal with some of these cases, and sometimes, rather many times, I would be dealing with people who are totally incompetent with dealing with managing the finances. They have the priorities all jumbled up. I don't know, you can't afford to pay your mobile and you've gone and taken out a car. I just don't understand it. But anyway, that's just me. What I'm trying to say over here is I don't know how these people end up dealing with these decisions.
I think you can get a perspective from, I'm sorry if I have to interrupt you. I apologize. From Antid, I think Melanie can speak from Jan Antid Foundation, and she will sort of explain, and I'm sure FSWS can also.
Thank you.
Yes, in fact, unfortunately, it's a reality that we face day to day. Being the foundation is supporting families and individuals that are at risk of poverty or social exclusion. Rather, lately, last year, we had an increase of 22% of individuals seeking support because of financial difficulties, where before the presenting problem would have been financial problem, family dynamics, housing issues, and other things that would lead to financial problems eventually, but it was not the presenting problem. Basically, they are coming for support because they don't have any money to purchase groceries to feed the family by the end of the month. So we've seen an increase, and it all leads to the lack of affordable housing, the low-paying jobs, the inflation that we had, and these are multiple effects that are affecting the people that are in work or on social benefits, but they manage to live from wage to wage, and they don't have any savings to save for a rainy day because the complex needs of their family, or could be also a mixture of lack of financial literacy or good financial management. It could lead to over-indebtedness. Unfortunately, from what we see, the institutions that you mentioned before, Dr. Kalea, also have a very strict and rigid way to recoup their debts. For example, when you have a family with 4 children, they are on social benefits because of certain issues and also mental health issues, they cannot work, so they are at the moment on social benefits, and they have an income of 681 a month, 681 euros a month, and they have to pay rent, electricity, the internet connection, because kids go to school and they need the internet connection, and the utility companies ask for a monthly repayment terms of 200 a month. How can they, with 480, survive? So when an emergency comes up, what is the first thing that they won't pay? It would be the telephone bill, the utility bill, and these will add up to over-indebtedness, and we are seeing a lot of families that are issued a garnishee order and they don't have any money in the bank account. And this is not because they were wise enough to put the money aside, because they actually don't have money to set aside. They just survive from one salary or one social benefit to another. So the need, yes, of a personal insolvency registration to, one, cover the creditors in one part, but also for the debtors to have sort of reference point or debt advisory services that could help them sort out their financial services, which comes along also with awareness to the telephone communication utility companies, awareness on how the repayment terms need to take into consideration the circumstances of the family rather than one size fits all approach across the border.
This is very, very interesting. Thank you very much. I mean, and what you're saying is pretty factual. One of the things which I think is really abhorrent, in my opinion, when it comes to particularly to utility services across the board, is that apart from the judicial procedure, the garnishee order, the judgments, etc., which incidentally judgments don't prescribe. So once you've got a judgment against you, it's there forever, unlike the credit itself. One of the things that I find which is really awful is the famous or notorious disconnection fee. So they disconnect you from the service. Now you want to reconnect because you have to pay now €295 to be reconnected to the service, etc. Which obviously is going to put greater pressure on these families to rehabilitate themselves back into the system.
And we are dealing with people that they don't have any access to credit. They don't have access to a credit card, access to a microloan or anything. So they are being left either not paying the bills and end up begging up for charity, for food, or else seeking illegal ways to get funding, as you said, usually. And that's a spiral that once you go into it, God knows how you can get out of it.
This is something that our foreign colleagues would not be aware of, but my Maltese friends here are fully aware of. I am not going to mention any trade names purposely. However, everybody knows who and what I'm talking about. There is a possibility now. It's a new kind of usury. It's a new kind of usury where you have the possibility of obtaining a car without placing any deposit, without paying any money. So it is a no deposit car system, okay? And all of a sudden you find yourself, because of the contract you've signed, you find yourself caught in this web where you have become beholden now to the car company, and you have to pay them, I don't know, €600 a month for a car which is never going to become yours. And they will come, take your car away, change it, give you a worse car. It's crazy. It's insanity. It's insanity of the highest order. And which brings me back, by the way, my colleague Dujardin here, and even my Maltese colleagues, this is a bit of law again, is that here in Malta, as a civil law country, I believe this definitely exists in France as well, is the respect that the law gives to the written contract. Pacta sunt servanda. We are servants to the contracts that we sign. So we've signed a service agreement with a utility service provider, pacta sunt servanda. With the car company, pacta sunt servanda. So the court is going to look at that contract and it's going to say that is the law between the parties. So there is the statute law, but now we have a special law, which is this contract, which you've signed with the bank, which you've signed with the credit institution, which you've signed with the utility company, which is the law between the parties, and you have to abide by those terms and conditions. And if you didn't want those terms and conditions, you shouldn't have signed it. Naturally, this legislation, because it is consumer protection legislation, and all this effort to protect from over-indebtedness, etc., I am seeing it right now as a potential inroad into this maxim of pacta sunt servanda. And this is, I mean, this is, if this takes off, and I'm pretty sure it will, because there seems to be the will, I'm pretty sure this is going to rock the foundations of this very, very, very important principle.
Okay, Pauline?
Sorry, really just 1 minute. When I had my first lesson of consumer law and over-indebtedness, about over-indebtedness in the faculty, the teacher said to us, all what you learn in civil law, you have to forget it now.
Very good. Do we have any more questions, please, or comments? No, so I would like to thank you all very much for what was a very interesting session, which we're really looking forward to. And I am sure there is more to come from the legal side, as you can see. And this session is recorded, so if you want to get back to it, I wanted to ask Pauline, can we pass on the presentation to the guests? Do you want to add anything to it?
No problem, you can send it.
Okay, thank you very much. So Archie, you can send it to the guests and also to the list, because I know there were people who wanted to make it, but they were abroad or they had other commitments. So if you could please forward, thank you so much once again. It's been a long time coming. I'm very happy with the session. Thank you so much.
Thank you. Thank you.
Thank you.
Thank
Bye
you.
bye.
Good day to all. Thank you.
See you
Thank you.
tomorrow, maybe.
See you.
Bye-bye.